And I love it. Personally, my older son, so I have a 5-year-old and 3.5-year-old, and my older son Caleb was just diagnosed with high functioning autism about 1.5 years ago. So at that point, I went from being a volunteer and support to actually being a parent of a special needs kid, and now I understand a lot more, driving him to different things. I totally believe in early intervention. He's really doing great. But there's a lot involved. So I commend you guys for, I assume many of you have family members with special needs, with Down syndrome, and it's a lot on your plate. So to take the time out and look at this as well, I understand that's a lot. So thank you for coming. Okay, so these are my credentials, but yada, yada, yada. All right, so let's talk about estate planning. And as Steve was saying, it's all about your goals. A lot of times when people say, okay, well, why would I do estate planning, especially for my disabled child? Is it to preserve public benefits? Well, that's one of the things. But I think that the most important one is to really maximize their quality of life. You want your child to live their best, most independent, most happiest life possible. And how are we going to set them up for success in that way? We also want to protect them from financial predators, which is a big thing. We want them to be, as I mentioned, as independent as possible. And we want to avoid the court system. In California, the court system is horrible. If you've moved here from another state, other states, their court systems are much easier, but here it's expensive, it's time-consuming, it's public. Ugh. So you may need to, if we're dealing with like a limited conservatorship, which we can talk about later. But when we're talking about estate planning, we do a lot of this so that we can avoid courts altogether. Oh, and by the way, as I'm talking, if you have a question, feel free to raise your hand. And I like the back and forth. I come from a family of lawyers and teachers, so I actually really enjoy the instructional nature. And if you're asking a question that I'm going to cover later on, then I'll just let you know. And sometimes it's a good segue, Okay, so there's a lot of different tools when you're doing estate planning, and they all kind of work together and have different goals and reasons. So the main one that we're talking about today is a special needs trust. We'll also be talking about an ABLE account, which I said is new. It's actually been a few years now, but it's not in California yet, so it's still kind of new. A revocable trust, which I won't be talking about that much, but you need to have a revocable trust. Limited conservatorship, durable power of attorney, and advanced healthcare directive. So those are kind of the different tools here. Okay, so what is a special needs trust? All right, so a trust is really, it's an agreement, it's a contract between the person setting it up, who we call the settlers or the grantors or the trustors, and the person managing it, the trustee, for the benefit of the beneficiary. So there's a lot of different types of trusts out there. The one that we're concerned about today mostly is the special needs trust. Okay, so this type of trust is irrevocable when it's funded. It can't be changed for several reasons, and we'll talk about those. It's intended to hold assets for your disabled child or family member, and it doesn't interfere with needs-based public benefits. So I also think of it like a safety net. It's there for whatever your child might need. It's very flexible. The money can be used for a lot of different things. All right, so Steve Dale is going to talk about this a lot more, but here are some different public benefits. If you have a child who's a little bit older, you've already experienced some of these. Before your child turns 18, your money is deemed to them. So they don't actually qualify for a lot of these benefits sometimes. But once they turn 18, they're an adult, right? Yeah. And so your money doesn't count anymore. So they're poor. They have under $2,000 in countable assets, and they can qualify for the means-tested public benefits. SSI, supplemental security income, is a monthly income stream that they can receive. Now in California, it's about $910 a month at the high end of what they can get. And then also Medi-Cal, which is California's version of the federal Medicaid system. It's imperfect, but it does provide a lot of what health insurance, what your child might need. And I have under a subsection of that in-home support services. So those are all things that Stephen can cover. Then you have other benefits that are not affected by how much money your child has, right? SSDI, Medicare, which is a different health insurance program that I'm sure you've heard of. And then we have Section 8 and low-income housing and regional center benefits, which have slightly different rules. But the ones that we're really concerned about is this first column here, because what happens if you die and your child inherits money outright? Let's say they get $100,000. Now they have more than $2,000, and they're bumped off their public benefits. Okay, so that's one of our concerns here. Instead, you leave it to them in a special needs trust. And somebody else is managing that trust. They don't actually have access to the money, so it doesn't count as their money. That's why it works. They don't have an ATM card. They can't say, I want my money now. I mean, they can say it, but they're not going to get it unless the trustee agrees, okay? So since they don't have direct access, it's not their money, and it doesn't count towards that $2,000 very low cap. Does that make sense? Okay. All right, so there's several different types of special needs trusts that you might run across. The main one that we're talking about today is our third-party fruity special needs trust. That's the one that you set up for your child. So you are the third party setting it up for the disabled beneficiary, okay? Anybody can set up except a spouse, can set up a special needs trust for a disabled person. So if you're a grandparent, if you're an aunt or uncle, you can set one up for the disabled person. What if you are the disabled beneficiary and you get money? For example, you've been working for a while and then you become disabled. Or you're in a car accident and you get a litigation settlement. Or your aunt wanted to be really nice and left you $50,000, and now you have money that's bumping you off of your public benefits. In that case, you as the disabled person or a parent, grandparent of the court can set up a first-party special needs trust. You are the disabled person. You are the first party. Okay? There's different rules for these types of trusts. The third one is a pooled special needs trust. So that's where you have a lot of smaller special needs trusts that kind of pool together their money, and a nonprofit will run that trust company. And I know Steve Dale is associated with one of the pooled trusts. So there's several in California. So if you look at the chart, so we have third-party special needs trust can be set up by about anybody, and upon death, it goes wherever you say. So when you set up the special needs trust, you say, okay, everything's for my disabled child, but then when my child dies, this is where I want it to go. You have to say that when you draft the special needs trust, okay? However, for a first-party special needs trust, and I also call it a D4A special needs trust. That's a first-party special needs trust. That's the statute that it comes from. That one, upon the disabled person's death, Medi-Cal wants their money back, okay? So they will submit a reimbursement claim. Let's say that Medi-Cal has paid out $300,000 over the disabled person's lifetime. Then they want $300,000 back, and then the remainder of it goes where you want. So you can see that a third-party special needs trust is much more beneficial in that way. Also, to set up a first-party special needs trust, the beneficiary has to be under age 65. Okay, it's just in the statute. So if you have a disabled person who's 70 who comes into money, then they can join a pooled trust, but they can't do a first-party special needs trust. There was a great change in the law last year that now allows a beneficiary to set up their own first-party special needs trust. Before that, they couldn't. The law was just, there was some sort of typo in the law, and they couldn't set up their own, but now they can, if they have capacity, of course. If they don't have capacity, you gotta go through court. Okay. Here we go. Who? Yay, one of those segues. All right. Okay, so this is such a difficult question oftentimes. Sometimes it's a no-brainer. Oh, my sister could totally do this. Well, your sister may not be around for your child's lifetime, right? I mean, your child might live another 70 years. Who's going to be around that long? So the trustee is really the surrogate financial parent for your child. So you can imagine how difficult this choice might be. A lot of people think of family members and friends. Sometimes they don't want to pay fees, or they just think this person will have a better relationship with my child. It can be a challenging choice, though, because they have to then get up to speed on all the different rules for those public benefits that I've mentioned and that Steve's going to talk about more. Okay. And then sometimes there's some sort of conflict of interest, right? You can name, okay, well, let's see. So Johnny needs the special needs trust, but his sister can be the trustee. But then upon Johnny's death, everything goes to his sister. So is his sister going to have the wherewithal to make the distributions that Johnny needs, or is she going to not, so that she can end up getting more? Now, notwithstanding that conflict, a lot of parents still will name the sibling. But let me just warn you, if your child has some sort of mental health challenge or some behavioral difficulties, that can really get in the way of the sibling relationship. So a lot of times I'll recommend that you don't name the sibling to manage the trust, just because you want the sibling to be the friend. You want them to come and take them out to the movies and to lunch. You don't want them to be the gatekeeper to the money. Does that make sense? Okay, so other ideas. There are private professional fiduciaries. What are those? All right, those are professional trustees. Oftentimes they've worked at banks for a while, they've been trust officers, and now they've gone out on their own, and they professionally manage trusts. That's what they do. One of the drawbacks of this, give me a second. One of the drawbacks of this is that a lot of times they're your age. They've been in this for a while. They're not going to be around for your kids. So you'll want to ask them, all right, what is your succession plan? Do you have somebody else waiting in the wings to take over? Sometimes they'll charge less than a bank. Sometimes, they might charge hourly as opposed to the flat fee that a bank or trust company might charge. So that can be more attractive, and they can also develop a personal relationship. So, they're open to being interviewed. So you can talk to them and say, all right, ask all your questions. How do you manage things? How much experience do you have with special needs beneficiaries, with the type of disability that my child has, and find out more. All right, banks can also be good choices. Not every bank wants to act as trustee of a special needs trust. A lot of banks, they just don't want to get into the public benefits rigmarole. And a lot of banks require at least $1 million in that special needs trust because they charge a percentage, 1.25% to 1.5% typically. And if there's not a lot of money in there, they're not going to be paid a lot. All right. There are a few banks, like Fremont Bank will take a trust as low as $250,000, a special needs trust, and they actually specialize in that. Wells Fargo Bank, Boston Private, there's a few other banks that do, but there aren't that many. So if you have a bank you really like working with, talk to them and say, okay, do you have any experience with this? And if they don't have the experience, you probably don't want to name them. There are some nonprofits that act as trustee. I know Jewish Children and Family Services does. There's one called Good Samaritan. Oftentimes, they're great choices and they're also really overworked. So, but they can be good options. Then you can combine them. So you can say, all right, I want to have a family member work as co-trustee with the bank. Okay, so that can work. Sometimes the bank doesn't want to work as co-trustee with an individual because the individual doesn't know what they're doing and the bank's taking on all the liability. But there are ways that you can mix and match. So a lot of times you might have a family member who wants to be involved, but they don't have the availability or the capacity to do the everyday work of contacting your loved one and saying, okay, what do you need? Making sure that the distributions are according to public benefits. there's a lot that's involved. They don't want to do the accountings, but instead what they can do is they can be the trust protector. So they basically they're the oversight. They get the power to get an accounting once a year, so they see how the money is spent. They can remove the currently acting trustee if they don't think things are going well, and they can replace them with another trustee, not themselves, but somebody else, maybe another corporate trustee or private professional fiduciary. And so that can be really powerful when you have a long-lasting trust. That I put here, there's no court involvement. So it's a good news that there's no court involvement. That saves a lot in fees, a lot of hassle. But the bad news is there's no court involvement, because courts are really good at oversight and making sure that money is spent appropriately, that your child is being looked after. So the trust protector is kind of the surrogate in that role. So what I see oftentimes is somebody will name a bank or a private professional fiduciary as trustee, which I think is very appropriate. And then they'll name a family member as trust protector. Okay. We can do co-trustees, as has been brought up a couple times, or an advisory committee. Now this can be a little bit more expensive, so I don't think it's as favored nowadays, but it's had a long history of being used for special needs trusts, where you name the psychiatrist, the doting uncle, the social worker, and they all meet up once a year or every other year to talk about how things are being administered in the special needs trust and to make recommendations to the trustee. So you can have as much involvement from other people or as little involvement as you like. Okay, so here's something that I often recommend. You know your child the very best of anyone. You know what therapies have worked, what therapies haven't worked. You know what foods set them off. You know their hobbies and what they really like to do and don't like to do. Write it all up. Write a letter, basically a letter to the trustee that you wish things that you wish they would know. Okay, and then this really helps in the transition of them taking over as trustee much more smoothly. Okay, so anything at all that might be helpful. Yes?
Can you update that letter?
Yes, update that letter frequently, because they might start eating a lot better, which I hope that my son does, or they might not. Yes, so right, in housing, what housing might work for them. Housing is such an incredibly important topic. We could talk just on housing for a day. But what preferences you might have. If you know of some really good group homes up in Santa Rosa, would that be a good choice, right? So anything, that's your chance to give your 2 cents worth and more. Okay, so we've talked a lot about setting up a special needs trust. I mean, the next step is really administering the special needs trust, which I'm not going to go into a ton. But I did want to connect with what Steve Wilcox was talking about. How do you fund this special needs trust? So money from your trust can go in there. Life insurance proceeds, that's actually a good way of funding a special needs trust, I think. Because that's really oftentimes when you need the money. When you're not there, you're not earning a salary anymore to take care of your child. Then you have this lump sum of money that goes into the special needs trust and can be used for whatever your child needs. Can the disabled child access the funds? No. So if you have a child who's a bit more high functioning and they want to use their cash, they do have the SSI funds. And now you can transfer money into an ABLE account. So we'll talk about that in a minute. And how does the trustee pay for items for the disabled child? So the trustee basically gets the invoice and pays it. Or the trustee can order something online and have it delivered straight to the child. If you have a child who's a bit more high functioning, you can give them a credit card with a low monthly balance, and they can use that credit card. You want to make sure that you can use a gift card, but make sure it can't be exchanged into cash. Okay, because again, no distribution of cash. If you're distributing cash, then SSI looks at that and they go, oh, they're getting an income. We can decrease what we're paying them because they already have a different income source. Okay, so ABLE Act, this is a relatively new thing, so I really like covering it. So it was signed into law December of 2014. It's basically a savings account for your child, your disabled child, that can receive up to, actually this year it's $15,000. It just went up from $14,000 to $15,000. So it's linked to the annual exclusion amount, however much you can give away during your lifetime without even having to report it to, or I'm sorry, not during your life, every year without reporting it to the IRS. Okay, so this year it's $15,000. So that ABLE account can receive up to $15,000 each year. Okay. And there's been a change to that, which it is even better, which I'll let you know. Okay. Who is eligible? You have to have been disabled before the age of 26. So if you have a child with Down syndrome, done. All right. Limitations. All right. So the age, it can be used for what we call qualified disability expenses. I think that's the name. Is that it? Yeah. Okay. Okay. So it's a little bit more restricted than a special needs trust. A special needs trust can send your child on a round-the-world vacation. All right. An ABLE account is not really meant to do that, but it can be used for just about anything your child needs. So it's pretty flexible. $15,000 is the amount that it can go in by any source, including the disabled person. However, the big change with the tax law is now the disabled child, if they're working, they can contribute and up to the federal poverty level. I think it's about $11,700. Additional. If they're earning that money, they can also put that in. So now the ABLE account can hold up to about $26,000, $27,000 per year. It can receive that per year. Now, so one of the limitations is that you can put in up to $100,000 over, and that would take 7, 8 years. And once it hits $100,000, the child's SSI benefits are suspended. They're not eliminated, but they're suspended. Okay, but the child can continue to receive Medi-Cal benefits. Okay, so as you might know, if you're receiving SSI, just $1 of SSI, you automatically qualify for Medi-Cal. So if your SSI is suspended because of the ABLE account, that doesn't mean that you're bumped off of Medi-Cal. You can just receive Medi-Cal a different way. Okay. So to be eligible, you actually have to have a qualifying disability. You can set up a special needs trust kind of for anybody, even if they don't have a diagnosis. But for ABLE Act, they need to have a qualifying disability. Down syndrome would be one. And we talked about they just get one ABLE account. So you can't set one up here and then another one here and there. They get one. Okay, so we talked about these things. Medi-Cal payback. This is so exciting. Okay, as of October of last year, we found out that once California is up and running, and even before then, Medi-Cal, the Department of Human Services, they're not going to try to get a reimbursement out of the ABLE account. No, they're not. And even if it's in another state, they're not going to pursue it. All right? So this is really good news for us. That's another very recent thing. Just in California, each state gets to decide whether or not they're going to go after ABLE accounts to get that reimbursement claim that we see like in first-party special needs trusts. They're not going to do it for ABLE accounts, which is great. Okay, so these are the changes that we were just talking about. Oh, also 529 accounts. Those actually can be rolled over $15,000 a year into an ABLE account. So it may not be in your situation, but in a situation where somebody has set up an account for a child and doesn't know of their diagnosis, and then later on they're not able to go to college, then and it's going to be distributed to them at a certain age and bump them off public benefits, you can roll over that money slowly over into an ABLE account, and then it won't disqualify them from public benefits. Okay, so it's not available yet in California, though we expect it soon. We're waiting, all right? And hold on one second. And so far, the most popular states to set up ABLE accounts have been, from what I understand, Ohio and Tennessee. You'll say, why Tennessee? Because they've actually subsidized the fees, so the fees are very low. And then Ohio has a nice structure online, so anybody can set up in those states. Not every ABLE account in every state can be accessed by a non-resident of that state, but these two states, they can be. Okay. So you can start now, exactly. And then once California is up and running, you can transfer it back to the California account. You may not want to. The terms might be better in that other state, but then you can. So you can start now. Oh, so here's a little picture of different states. So the states in blue do have ABLE accounts. The ones in green do not yet. Hopefully it'll keep getting more and more blue. Okay, so I have a little chart. You guys can look at it later because I don't have much time. Okay, so now I want to talk about what this structure looks like. We have this special needs, this special needs trust just sitting there doing nothing. How do we get money into it? How does it relate to a pour over will? Let's see. Sorry, thank you. There we go. Okay. So you basically set up your revocable living trust, and you say, okay, upon my death, this percentage or all of it or whatever goes to the special needs trust for my child. And here's your special needs trust. What is a pour over will? That's basically a cleanup document where you say, if I forgot to put anything into the trust, this scoops it up and pours it over into the trust. So if you've done your funding correctly, if you've put the assets that you need to into the trust, your residence, your mutual funds, brokerage accounts, into the trust, then it passes correctly. You really only use the pour over will if you forgot to put something into the trust. But also, very importantly, the pour over will is where you nominate guardians. Okay, if you have a child who's under age 18, you want to say who's going to be raising them. All right, and you're nominating somebody. This process always goes through the court system. Whenever you're dealing with minors, the court wants to be involved because you may have nominated your sister, but now she's a drug addict. We want to make sure that the person that you've nominated is really the right person to do the job. Okay, so that's really what a pour over will is. It's confusing because back before the early 80s, wills were used for just about everything. So you'd say where everything goes, you'd say who's the executor, you only used a will. And even nowadays in movies, you say, I hereby bequeath everything, So people don't understand that in the early 80s or late 70s, these revocable living trusts were developed to avoid the court system. And now it's the trust document itself that's so important. So you name the trustee of your revocable living trust. You name, where things are going to go. And everything is basically spelled out in that trust how it's going to be administered later, just like in the special needs trust. Okay. Is that helpful? Okay, next. There we go. Okay, so that kind of shows how it funds. Conservatorship, I'm going to just really skim over this. This could be its own presentation. If your child has very limited capacity or no capacity at all, and you think that they might be subject to financial predators, or they might not be cooperative with medical decision making, or they can't communicate their wishes at all, then you might need to go to court and ask the judge to allow you to make decisions on behalf of your child. This is after age 18. So up until age 18, you're making their decisions. After 18, as we laughed about before, they're the adult, and they can say, Mom, I don't want you in the room with the doctor, or I don't want that shot, or I don't want that surgery, or yes, I'll sign that credit card account and rack up $50,000 of debt, right? So this is to prevent that. Now, not every child. There's some attorneys who say, okay, your child turns 18, they have a disability, let's go straight to court. I don't really have that approach. I think every child is different. And you look and you see, okay, are they cooperative with you? Are they, do they understand what's going on? Are they going to ask you first before they sign to set up a credit card? If you can avoid it, I say, hey, no reason to. It can also be stressful. As you go through the process, your child will be interviewed by a court investigator. Other people will be interviewed as well. You all have to go to the court for the hearing, and it's expensive and it takes a while. So if you need to, go ahead. But I can talk about this offline, but I did want to just let you know there is that option out there to basically take over your child's ability to enter contracts, make medical decisions, choose where they're going to live, make decisions about their education, And if your child objects to this, you're off to the races. Okay. Oh boy, I jumped ahead. There's 3 types of conservatorships. There's regular conservatorship, which is usually for adults who are getting older and getting dementia. Limited conservatorship, that's what we're talking about for your children. If you have a child with developmental disabilities, if they're part of the regional center, you'd get a limited conservatorship. 5150 is for folks with severe mental health challenges. All right, so what if you don't do a conservatorship? Then you can get a durable power of attorney and advanced health care directive. And I hope that everybody in this room, you all look like you're over 18. I hope you all have durable powers of attorney and advanced health care directives. So what does this do? This allows somebody else to sign your name on financial documents. All right? So if you have a bank account that's held just in your name, somebody else can access that bank account. Now I can't guarantee that the bank will accept it because banks can be kind of difficult, but they should. All right? So you're saying, you know, who has the authority to sign, and there's a lot of powers that you want to list out. All right, and it's very, very, very important. You know, hopefully it won't be needed, but if it is, you want it there. All right, and so if you have a child who has some capacity, they can sign their own durable power of attorney. Then you don't have to go to court, you know, because then you have the ability to sign on their behalf. Last document, Advanced Healthcare Directive. Again, everybody should have this. You guys remember Terry Schiavo in Florida? She didn't have an Advanced Healthcare Directive. People didn't know what she wanted done when she was in a persistent vegetative state. And so in the Healthcare Directive, you spell out, what if I'm unconscious? What treatments do I want? What don't I want? Burial or cremation, organ donation's okay, and you name your agent who's really your advocate at the hospital to go and tell the doctor, hey, this is what she wants. Please carry out her wishes. Okay, so we kind of talked about pros and cons here. Real life examples. This can be helpful. So, all right, so you have a family. They have 3 kids. One of their kids has special needs and 2 younger typical children. Who knows, they're girls, so they might be giving you even more grief as they get a little bit older. But you know, what kind of planning do they need? Which of these tools that we talked about do you think they need? What do you think?
Special needs trust.
Special needs trust for the son. What else? Able account. Able account can be very helpful. The revocable trust for the parents, right? What else? Durable powers of attorney, advanced healthcare directives. Those are important.
Definitely a will.
Right, the pour-over will is part of it. Yep. Right, they should name guardians in their pour-over will for their minor children. Yeah, so all of these things kind of work together, right? Okay. All right, now you have an adult who has special needs and works part-time. What planning does she need? Might be a little different. What do you think? Able account's awesome. Yes, what else?
Possibly power of attorney and the durable.
Right, advanced healthcare directive and power of attorney. Exactly. Yep, she might need a revocable trust. I mean, it kind of depends on, or probably not, but she might need a will if she has anything held somewhere. All right, so here's a family, and they have a 12-year-old son who doesn't have capacity and can't communicate or work. What do you think they might need? Conservatorship, exactly. And then they need their own estate plan, right? But this would be a situation where you really do need a conservatorship. All right, so here's a disabled adult who just received an inheritance from her aunt. That horrible $50,000 inheritance. Okay, what do you think? What might she need? First party special needs trust. That could be a good thing. Yeah, because she wants to protect that right away so she can protect her benefits.